I am that I forgot to do when we started, which we need to always remember. And this is part of the technological adjustments that we will have to make. Once you come out of your breakout rooms or you make a pause, you always have to have a mental reminder to restart back the recording of things that you're recording. Somehow, none of the technology allows this to be done automatically, so it has to be a manual process. The things that you have to build into your case management process, who is going to be in charge of that, reminders for things like that, ensuring that the platform that you're using has those security features that you can restrict commenting, you can restrict any posting of documents, because even in the chat, you can send files and documents in the chat. So those kinds of, that awareness has to be there. It is not going to be the case that we can avoid this, unfortunately. Going forward, this is now entrenched into the practice and it is going to continue. So we will have to make those necessary adjustments. The practice directions that have come out of COVID have dealt with quite a bit of this, but there are still some areas that are not specifically covered. As I said before, the details about the kinds of platforms and the different amenities that are available on each platform and how you restrict the use of those amenities. The consideration also about who will record, because you don't want a defendant recording and then sharing things outside of the courtroom space. You have to give those kinds of directions about that. You won't be able to disable their recording device. You won't even be able to know if they have a phone somewhere on a table that is still recording it, that is out of the line of your site. But the powers for addressing any infringement need to be there, and you need to inform them of the penalties and the consequences of any infringement of the orders and the directions that are given. And then ensure that you have designated spaces for those things that need to be done, such as the recording. Who's going to be doing that? There's a designated space for that to be done. And then one of the things that has also emerged is the judge alone trials. So in some of your jurisdictions, this is not yet happening, but quite a number of jurisdictions, when we did the consultations, have indicated that discussions are happening about whether this is the direction that they will go in and how that will change the nature of proceedings and what considerations need to be done. In the guidelines, we presented Belize as an example of a best practice for countries that are having that discussion now to look at what has happened in Belize. Belize started judge alone trials back in 2011 in capital offenses. So they have now had over a decade, over 10 years of experience doing judge alone trials. This year, in capital offenses and some other offenses related to firearms. This year, they expanded the judge alone trials to sexual offenses. And so now that provision is there. And so we have not had any pushback to the judge alone trials. The earlier ones that we did in 2011, there were some applications that were made, but all of them were unsuccessful. They had one that went up to the CCJ that ruled against the applicant. So they're pretty much now entrenched. I think eventually most of our cases would be going to judge alone spaces where we seem to be moving away from jury trials, and the public doesn't seem to be bothered much by that. There is the contemplation though in some jurisdictions of an option where the defendant can apply for a judge alone trial, whereas in Belize, it's mandated. So in Belize, all sexual offenses must now be judge alone trials. The law doesn't give that room for the defendant to choose or for the prosecutor to apply. It is mandated. Jurisdictions like Antigua, they're moving towards more options of having application, when then the court then has to consider what should be the circumstances in which the judge alone trial should be allowed, what considerations need to be in place. There is guidance in the legislation for how that is to be done. And the legislation will be your first guide as to how that should be done. But there is, of course, the evidence that judge-alone trials tend to move quicker. They do tend to get matters through the court at a quicker pace. There, in sexual offenses, we are seeing that they also are able to address and remove some of the issues we have had in the past with jury bias and some of the stereotyping issues. It doesn't mean that you no longer give these directions. We will talk about that when we talk about summing up, but it has removed some of that. And so that has been useful. In terms, also I gave in the model guidelines example of Belize. And then in terms of the trial process as well, there are special measures that have to be considered once somebody has been identified as a vulnerable or intimidated person. One of the things that the guidelines has established is that even before the trial process, special measures can be used. So the police can use special measures where they have a vulnerable witness, and now in Belize, the law provides them that option of additional special measures, more than just the traditional ones of recording, the statement, having a support person, using interpreter, or using anatomically correct dogs or aids in interpretation. Those have been the traditional ones. They now have additional ones that they can use even from the investigative process. Any special measure that was used in the investigative process is most likely going to be needed at trial. So the case management process must inquire about that and must make the proper directions for the continuation of their use, and then make the directions for how the court will accommodate their use, because not all the special measures are readily available to the court. I know that in Belize, our laws, the Protection of Witness Act, as well as the practices for the court, allow for the use of screens, but I don't know that all of our courts have a screen. So directions have to be given about how those special measures will actually be used in court, if they need to be brought from somewhere, if they need to be modified in some way to make them useful. If we have, for instance, a complainant who has a physical disability and they need to modify this court space to allow the screen to be used, those kinds of things have to be contemplated. And where we are having the aids to communication, where you're going to have a specialist coming in to assist somebody, for instance, who has speech impediments, or who requires a specialist to be able to interpret sounds that they are making and to be able to get the court to understand, or to use sign language. Those things have to be provided for. Not all of our courts have access to persons who are registered with the court in this capacity. So where those persons will be sourced also have to be contemplated. You want to ensure, sometimes we have discussed in the past in trainings with judicial officers that sometimes family members are not necessarily the best persons for this kind of thing, because there may be challenges for them to remain objective and not influence what the person is going to say. And the court won't necessarily have a way of identifying if they're influencing what the person is saying or if they're interpreting correctly. So you need persons who are neutral, who are objective, preferably persons with some kind of training as to the processes of the court and some familiarity with the evidentiary rules of court and the requirements of the court process. That would be a help, but that is not always available. This is why in the guidelines, in the revised guidelines, there is this renewed emphasis on building collaborations with entities outside of the court process, whether it be private sector entities or NGOs who are already working in these spaces, who may have already developed expertise in these areas and who can then lend that experience to the court and allow the court, in a matter where that expertise is needed, to have access to that, so that the witness or the complainant who is appearing before the court is able to have those facilities. So all of those things have to be considered. And if it wasn't done in the case management process, but once the trial starts, it becomes clear that it is needed, then at that point it should be done. One of the things that the guidelines talk about is this need to constantly be revisiting and updating any directions that were given as the circumstances change and as the needs of the defendant and the complainant in the trial process changes, that we need to revisit that and ensure that those things are still operational. In terms of the intermediaries, we did give an example in the revised model guidelines. This was there in the original guidelines. It still continues, so we have kept it in the revised guidelines in St. Vincent, where one, they don't allow the unrepresented defendant to cross-examine a child complainant of a sexual offense, and where if the child complainant is not able to understand the processes of the court because of age or development, an intermediary can be brought in, a social worker, somebody who is a specialist working with, for instance, a child that has a learning disability or other form of disability, can be brought in as an intermediary to break down the questions to the level that the child would understand and to present it in a way that the child would understand. So the intermediary is an expert that is assisting the court in being able to ensure that the witness or it doesn't have to be the complainant, but any witness in the case who needs that capacity to give the best evidence is able to do so. This is something that other jurisdictions can do. You won't necessarily need legislative amendment to do that. That can be part of the magistrate, the judicial officer management of the process, but it would be necessary for you to discuss that in the case management process and to give those directions at that stage. Increasingly too, there is discussion about using previously recorded statements, video recordings of the statement that was given to the police as the examination in chief, especially in relation to child complainants in sexual offense cases, to minimize the possibility of the re-victimization and to address any kind of intimidation that the child may feel in appearing before the court and experiencing very aggressive cross-examination. But where that is done, of course, any directions in terms of ensuring any inadmissible content is dealt with and any other legal issues that the defendants may have objection to have to be dealt with before that can be admitted. And again, the case management process is the point at which that is done. But if it was not done there and it becomes clear at the beginning of the trial that this complainant is not going to be in any frame of mind or any way, shape or form able to give live evidence, then it would become necessary to have that hearing within the hearing, the voir dire, or to have that process to erase that and for the court to make the appropriate directions. So I see in the chat, Justice Maurice Ramlal from Guyana is expressing in Guyana that the defendant cannot be prohibited from personally cross-examining the virtual complainant. So again, the peculiarities of your jurisdiction may impact how much you can do that. I shared before the Protection of Witnesses Act in Belize that now gives the court specific powers to do that. There are other jurisdictions where criminal procedure rules in Guyana and Trinidad are also putting restrictions on that. So your specific jurisdiction, as it relates to the rights of cross-examination, you will have to be guided by your criminal procedure rules, but the court always has a power to manage the proceedings. So even if the defendant, there is already learning that is coming out of the UK that is saying that these special measures do not infringe that constitutional right of the defendant to cross-examine. It merely provides the capacity or the facility through which that cross-examination can be done, that he doesn't have to do it himself for him to have the right to cross-examine. So it can, of course, when he's doing it through an attorney, he's not cross-examining himself. So it's not infringing his right. So there are things that the court can still do in terms of giving directions as to a line of questioning, ensuring that the person is not badgering the complainant, ensuring that they give directions about the need for any support person to be in the court. All of those things are measures that can be done, even if your jurisdiction does not specifically have provisions in your criminal procedure rules or in any other legislation prohibiting an unrepresented person from personally cross-examining a defendant. We also gave the best practice from Antigua, where the court, as part of the management of the court process, can ask, and any jurisdiction can do this, you don't need a law to tell you to do that, an attorney who is present in court to volunteer to do the cross-examination and to assist the unrepresented person in doing the cross-examination so that that person is not personally cross-examining a vulnerable witness, right? That's something that can be done. Before I move on from that, I see Justice Ramla's hand is up. Is there something you want to add to that? Go ahead, Justice Ramla, you can unmute your mic.
Just for clarification of my concern or observation, in the face of our constitutional provision, if the accused insists that he wants to represent himself, there is no basis upon which a court can say that he has to cross-examine the virtual complainant through an attorney. True enough, you may suggest that an attorney can represent him, and if the attorney is willing, then it works out. But if he insists that he wants to personally conduct his defense, then we cannot follow that aspect of the guidelines.
Yes, but what I'm saying is that even in the light of that, you can still use other protective special measures using.
This is specific to the issue of him not being able to personally cross-examine the complainant.
Yes, but it's all related. So I'm saying that if you don't have the power in a legislation to prohibit that part of it, and you still have concerns that if he does that, it is going to affect somebody that you have declared a vulnerable witness, you can still use those other special measures to minimize the impact of that, such as the screens.
Certainly. Actually, we do not have a difficulty because those things are legislated for in our act. But my concern was just with that aspect of it. And I did also type another concern which I had, which is in relation to the other jurisdictions. Because there's only so much that you can do and be justified in doing by drawing on your general power to manage your court and to protect the parties that appear before you. So my concern was if you have a positive provision in an act which says that you have to follow, you can only order in-camera proceedings in certain cases, then outside of that, can you draw on subsidiary legislation or on the guidelines? That is my difficulty, because a subsidiary legislation, for example, criminal procedure rules cannot override an act. So that was my concern, albeit we do not have the difficulty in Guyana.
Yeah. In those other, I can't think of any jurisdiction in the Caribbean that will prevent a court from being able to have proceedings in camera. The court, usually that is covered for in the powers of the court to protect the interests of justice, again, when you're dealing with vulnerable complainants. And also in common law, there is a lot of learning on that. So I don't think there's going to be any case when we were doing this and we discussed with the different judiciaries and the legal teams and the persons throughout the Caribbean, there wasn't anyone that indicated that there would be any jurisdiction where it would not be possible to do an in-camera proceedings. So they got all the guidelines, have been vetted by the different jurisdictions throughout the Caribbean. We have had the input of all of the persons for them to be able the guidelines have been framed in a way that they will allow what is the prevailing practice, much of which has come to practice directions of the court based on the legal mandates that have been given for them to be able to facilitate the implementation of the guidelines.
Thank you. I don't confess to be familiar with the provisions of all the other jurisdictions. I just got a sense from what you were saying that there had to be a determination that the witness is vulnerable, whereas we don't have to do that. Any complainant is entitled to all the measures. So my concern was, what if the witness did not qualify, or the complainant did not qualify as being vulnerable in terms of the legislation? Then what can the court properly draw from then to order the in-camera proceedings? That was my concern. But I think from your response, I get a sense of what the situation is likely to be in those countries when they're faced with that.
Yeah. All right. Thank you so much for that. And certainly, as is also mentioned by SC, Justice Lam as an indication here, in the aim, of course, is to strengthen best practice. And that's exactly why the guidelines have been developed, right? We are sharing the emergence of what is happening in terms of the legal learning. We're going to be sharing with you some of the case law as well, coming from the CCJ when we go on to deal with sentencing guidelines, and even with the summing up what's coming out from the Commonwealth. So all of that has fed into the development of the guidelines. And as I said before, the vetting process has been extensive. We are confident that these guidelines represent the best practice of what you are able to do in the Caribbean in terms of the management of the court proceedings, either from powers that have been given by the legislature, powers that have come to you from the common law processes in the High Court, and powers that are attached to the management ability in the Magistrate Court, and the practice directions that have also come down for the Magistrate Court and the High Court through your different heads of judiciaries. And so the part two that we want to emphasize a bit in this trial process, the summing up process, there's quite a bit of direction that's coming for that. More and more jurisdictions are moving towards having specified criminal procedure rules that deal quite extensively with the summing up process. I mentioned before Trinidad and Tobago, their bench book and their criminal procedure rules give overall guidance, but they now have a specific bench book that goes even further than what is coming out of the Commonwealth jurisdictions and the case law from the UK, to give specific guidance in terms of all of what is required to be covered in the summing up process. And in some cases, it is going to be important for you to be aware of some of those things where it is applicable for you. If it's not applicable for you to draw on Commonwealth case law, then you have to look at what's coming out from the CCJ, what's coming out from the region. You have to look at what's available in your criminal procedure rules, and the guidelines will help you to identify some of that, because we give specific examples of what are some of the things that you can look at in terms of being able to see where you can get guidance. One of the things that we want to ensure is that judges have access to all of the latest information that is available, so that they can directly cover all the things that they need to cover in the summing up, to minimize the possibilities of appeal and to ensure that they are providing the guidance that is required in the best way that they can. So in We will have a little discussion about that in this next breakout room activity. I see we're already having a discussion in the chat, so I'm going to give you that space to take it in the breakout room that you can discuss it some more. So we're going to open back the breakout rooms. Salima?
I'm here.
You're ready?
Yes.
All right, I'm going to open up the breakout rooms. Again, you will have 10 minutes and you will discuss, basically we're discussing the summing up process, what you can do in your jurisdiction, what guidance is available. You can discuss whether you can draw from the Commonwealth or draw from regional case law. The guidelines present both, and we want for you to choose what is applicable to your situation. It will take a minute to get you into all of the rooms. And then your discussions can continue. Salima will be leading group 1 and I will be in group 2. Room. And in this section, module 4, which is the final part of the session today, and also the final part of the model guidelines, we are giving you this guidance for what are some of the considerations in setting up a specialized sexual offenses court. And much of this has come from the learning from Guyana and Antigua in the processes that they went through in setting up their specialized sexual offenses court. These steps and the guidance that's given here is also helpful in helping to strengthen those existing courts. And so countries who are also thinking about establishing sexual offenses courts, this is something that may be helpful to you to look at. One of the things that came out from the consultations was the need to have a group that's really pushing this, a small working group or a working team that's responsible for mobilizing the support and it's going to work in the background as well as in the forefront to mobilize the other stakeholders that need to be a part of this process is key. It's one of the things that we have seen as we did the consultations across the region. Many people were saying that they feel that there is a need to have specialized courts, that they see that in most of our jurisdictions, because of the increased number of murder, firearm cases that are coming before the courts are getting inundated with these cases that take priority in many cases over sexual offenses. And sexual offenses are sometimes they're not able to get on the docket as quickly and efficiently as they should. And one of the things that we have seen from the statistical data in the region is that the longer those cases stay on the docket, the quicker the witnesses, the complainants are to withdraw from the cases and not want to participate. In many cases, in sexual offense cases, the complainant, especially where the complainant was a child, years that pass, the complainant moves on, establishes a different life, may now become an adult and have not shared with their partner that they were a victim of a sexual offense and do not wish to revisit that because it may have social consequences for them now. And so they don't want to proceed. So a number of these cases that are remaining too long on the cause list are not going forward. Eventually, they will probably have to be withdrawn and null prosecutions entered because the complainants don't want to participate anymore. In some of the cases, the other witnesses are no longer available. They have left the jurisdiction. People move on, migrate. They don't want to participate. Evidence may have been misplaced. Court files or police records may have been lost. And generally, the learning is that the more delay that there is in sexual offense cases, the less likely are we going to have a resolution that actually involves a trial and hearing of the case. And some cases, null prosecute is the best option because some cases that go to trial probably shouldn't go to trial. But you want to minimize any situation where a case that probably should have gone to trial was not able to go to trial because it took so long that the person no longer wanted to participate. So one of the things that has come up is that a way to avoid that is to have these specialized courts that can bring this focused attention on this issue that not only has impacts for justice, but also has impacts for recovery of the persons that are involved in the proceedings as complainants, and also impacts for the community as a whole. So they're having that support from the head, whether it's the Chief Justice or the Attorney General, is key. And that has to be secured by a smaller working group or a champion, as somebody as in Guyana has started out discussions with the Chancellor and the Chief Justice, and from there spiraled, other persons were brought in, and they developed the working group and pushed forward and did quite a bit of it just from the judicial administration of the court. So that's important. It's also important to identify who are those other key persons that need to be involved. I mean, you will have decisions to be made about budgets. Who is responsible for that? Who needs to be involved in that process? It's important to then enlist those persons into a working group that over a period of time are going to bring the issues out that need to be addressed and decisions need to be made on what needs to be put in place, the gaps that are to be filled short-term and long-term, what needs to be done first, because you can't do everything at the same time. You will have to establish some kind of prioritization, and the other things that need to happen after that, what should we do first? And that will require some kind of assessment of what is actually already in place and what actually exists and what those gaps are. So all of those things are important. And in terms of the next steps after you have done that, you have to then begin to have the working group become more formalized and into a more coordinated mechanism that now will establish timelines for when they want things to be done, timelines for establishing if we need to have legal reforms so that we can have the court in place. How will we ensure that that is done? Who will be responsible for doing that? What groups or agencies will push that process? Timelines for if we need to identify a space where the court will actually exist and that will occupy, where will that be? Who will be responsible for that? Those kinds of things. So all of those considerations have to be put in place. And then one of the probably the more important things that the working group has to do is to educate the stakeholders on what the specialized sexual offense court will do. What is the aim of having it? How is it going to function? What are some of the things that needs to be in place? The continued advocacy work that is required by the group, and in terms of ensuring that the laws are going to be in place, that there's going to be practice directions from the Chief Justice, and in terms of the directions that need to be given for the court, the guidelines is these guidelines, revised model guidelines, have been used effectively in the existing specialized sexual offenses court that are in the region, and we are certainly recommending them as a tool for other jurisdictions that are considering to establish their own specialized sexual offenses court. And then you also have to think about the long-term functioning and operations of the court and the other support that it will need. One of the things that has definitely come up, the exercise that was done to collect information from Guyana and Antigua as to some of the practices and the achievements and challenges that they had been facing in knowledge exchange. Earlier this year, identified the need for better data collection in the court system and monitoring and evaluation processes, that we need to very early on establish those roles and establish the mechanism for how it is to be done. So if we are going to be tracking disposal rates, tracking resolution of cases, there has to be some way that that information is being collected and being fed into a database. There has to be somebody who is going to be responsible for analyzing that data, or some mechanism that can be used where the system can provide that analysis and generate reports so that the decision makers, both the judge and the administrators, are aware of what is happening so that if changes need to be made, they can be made. It also means that the court will require more specialized services from the persons whose work feed into the court, specifically police, social services, medical services. And those organizations will also need to be strengthened. And the working group may have to advocate for that and champion that. So best practice scenarios that we're seeing in the Caribbean is to have the working group actually be comprised of all of those entities, representatives from the medical field, from social services, government, non-government bodies, from the police and law enforcement bodies, so that they have an overall view of the different components that are required for the effective working of a specialized court, and can begin from the earliest stages of discussing the establishment of the court to advocate for those other reforms that are going to be needed to ensure that the court functions as it should. It also needs to have very strong, responsive survivor support. And we are seeing this comes out through the guidelines, and this is coming out from what we have gathered on the ground, the interviews that were done. All of the data that was collected is showing this need for very strong and responsive survivor support from the earliest stages when reports are made to the end of the matter, and in some cases, even beyond the end of the matter in the court system. This cannot be done just by the court. The court is not in a position to provide that. So it requires collaboration with these other stakeholders on the government side, the social services partners, child care partners who are responsible for providing that mandate, but it also will require collaborations and partnership with non-government organizations, because especially in situations involving vulnerable persons, such as most complainants of sexual offenses, they may actually have contact with an NGO or a CSO, civil society organization, non-governmental organization, even before they have contact with a government agency. And in many cases in the Caribbean, the government agencies are also contracting and signing MOUs with some of the CSOs and NGO organizations to provide aspects of psychosocial support and care. So those organizations also have to be included in the process in order for there to be accessibility on the ground for survivors to actual services for victim care and protection. So we also see that in the Caribbean, as somebody mentioned earlier, the victims don't come with just one situation or one need. There are multifaceted needs because they are coming from situations where their diversity, ethnicity, sexual orientation, the fact that they have a disability, language barriers, all of these other things are also impacting the services that they need. And so the court must also have this multi-dimensional view and this multi-dimensional lens to how we address cultural, social, behavioral change and needs of the persons who are accessing services from the court. These supportive measures that are used must ensure equitable access by the persons who are using the court. So they must be fair to the complainants and be fair to the defendants, even while they may have a strong victim-centered approach. We also see that all of this has to be done based on the context of the jurisdiction where you are and what you have, what is realistic for what you can do on the ground, and the order in which you can employ these elements and characteristics will depend on that. What resources are available, what are the actual needs, and what are the priorities for your jurisdiction in terms of how the court functions and who it targets and what services it provides. But we see that there is much that can be done. The learning that has come from Antigua and from Guyana is showing us that even though there is some input from international organizations in terms of some of the budgetary assistance, even without that, there is still much that the jurisdictions themselves can do in collecting data on what is happening in sexual offenses and their disposal in their jurisdiction right now so that they can establish whether there is actually a need for a specialized court. Looking at what is emerging in terms of how the public is expressing the need for more support and training and education on sexual offenses, looking at the agencies that are already working in the field, what services they're offering, and the collaborations that are already existing and how those can be strengthened. Those are things that can be done from the onset without much additional resources, especially financial resources, being inputted. At some point, there is going to be the need for that, but certainly the case can be made and the support can then be sought once there's a good handle on what the actual needs are and what the way forward should be. So that's the recommendation that the guidelines give. They talk and we go into more detail about what this means in terms of having this effective multi-sectoral coordination. One, we discussed that it is necessary to actually get the court off the ground, to get it started. But beyond that, the long-term sustainability of the court, the long-term effectiveness of the court will depend on this. As I said before, there are going to be services that the court is not going to be able to provide itself, where it must depend on these other stakeholders and them being able to partner effectively with the court system to achieve that same end goal is very important. The need for ongoing education and training has been highlighted several times today. That's something that has to happen. One, not just, as was mentioned before, in terms of educating the public, but even court staff and judicial officers and other persons whose work support the court system, police, social services, medical services. Those persons are going to need continued ongoing education and training as we have, one, changes in laws that impact how offenses are adjudicated, such as we're having now in Belize. Education is going to be needed. As we have changes in how survivors are treated in court, there's stronger emphasis that's coming out from the CCJ, from the Commonwealth, and the need to ensure that the processes provide adequate protection and care for complainants, witnesses, and persons appearing before the court. That has to be addressed. And then the consistency, that once the processes get started and the court is in place, to ensure that there is consistency in its practice, that a lot of this depends on the persons that are actually hired. But to develop that practice, it comes from using standardized tools, and the guidelines provide a standardized tool that can help to develop the practice that builds that culture of responsiveness in a way that is good for victim care as well as protection of the rights of defendants. And I mentioned before the need for continuous evaluation to ensure that this system is actually doing what it should and what we are saying that it is doing. That has to be built in from the beginning. That generally is expensive, but it is necessary. In addition to that, in terms of the actual support services, we see more countries moving towards this idea of either having one-stop shops, as in Jamaica with SOCA, or coordinated mechanisms, as in Antigua with SARC, where there are specialized persons that are dealing with victims from the point of making report, specialized persons in the medical field, specialized persons in social services that have this added lens of, one, the gendered perspective of sexual offenses, two, the trauma needs of complainants and survivors of sexual offenses, and three are also able to give information on the processes, accessing services, the information about court processes, and supporting persons to access those services. That is coming a key feature in all of the jurisdictions in how gender-based violence, sexual offenses are now being treated. And then as the court chooses its judicial officers, it's also important to ensure that that same reflection is happening in the choice of judicial officers. The Jurist Project supported several initiatives throughout the region. In Belize, for instance, we now have gender protocols for judicial officers that governs the magistrate court and the high court that was supported by the Juris Project that help the judicial officers to address bias and to understand the complications of dealing with victims of sexual offenses in the court system. It's not going to be the same as dealing with a victim of robbery or victim of damage to personal property or something like that. So having this specific tool and continued training for judicial officers as part of their professional development is important, but also selecting judicial officers that have some awareness of that already or some sensitivity towards that is also important. And then ensuring that there is this responsiveness, as we mentioned before, that we are moving things through the judicial system in an efficient way is perhaps one of the key directions that are coming from the CCJ that throughout the Caribbean, we need to address this issue of delay. Delay is actually injustice to both complainants and to accused persons. That the system has to be more responsive, that we have to move things through a timely manner. Some of that is outside of the remit of the judiciary because you don't control the medical services or the police and how quickly they do things. But as we have indicated in the guidelines, you can still provide that oversight role to set those specific timelines that things are moved through in an efficient manner as much as possible. And then having that need to recognize the changing norms, cultural, social norms of the community, and how the actions of the court influence that and provides a space for public education to address those norms, and how the court can educate the public on stereotypes and bias and those kinds of things is also important. Then to ensure that all complainants, persons with disabilities, persons who are from indigenous communities, persons who are minorities, persons with differing sexual orientation have the same equitable access to the court services as all persons. That's also an important thing that has to be considered. And this requires much more use of special measures and also the courts to increase their capacity to have access to those special measures in the court system for all complainants. So those guidelines will help those courts that are thinking of creating specialized sexual offense courts or having a dedicated judicial officer that will operate their court as a sexual offense court. The guidelines will help them with that. We shared the best practices, and in the guidelines, of course, those persons can also be contacted for further information. The Antigua Sexual Offense Court, Justice Smith is the High Court judge that is in that court. And we have representatives here from Guyana, from their sexual offenses courts can also give guidance. So with that, we have come to the end of the session. Before I give my closing remarks, I'll turn over a bit to Salima and Justice Rajnath Lee for them to give their closing remarks and any further instructions. And then I will give a space for any comments and questions, and then a final wrap up from me. Salima?
I don't really have any extensive remarks, but just to thank everyone for their participation today. I personally benefit from some of the discussions, and I think the discussion pointed really to that there's a lot of work that still needs to be done, not only with the court systems, but all the other actors that influence what happens in the court. And I'm also happy to hear the interest in other jurisdictions and how they may implement those model guidelines moving forward. But again, just to thank you for your contributions. And Diana, thank you for leading the session today. I really appreciate it. So if there is anything else that is needed after this session, please feel free to reach out to me. I will be sharing the recording and the PowerPoint presentation with everyone today, so that, because I think what Diana has here really is an excellent resource. While we have the full guidelines, I think this presents a really nice summary of some key aspects of the guidelines that will be useful for your courtrooms. So we'll be definitely sharing that as a resource after this meeting. Justice Rajnath-Lee, do you have anything else you'd like to say?
Thank you, Salima. No, I'd just like to say thanks. Thanks to Diana for a day full of wonderful discussion. Thank you for taking us to places that we may not want to go, or we wouldn't go so willingly. But thank you. And to all my colleagues, I look forward to seeing some of you, I hope, in St. Lucia next week. And just again, thanks. So Dana, I wondered whether I could ask you this. When you did your focus groups or your consultations, was there anything as to the sexual offenses courts, whether in Guyana or in Antigua, that have really worked well? Is there that one thing that has really worked well? And is there that one thing that needs real improvement? I've been thinking about it for the last few days. Thank you, and thanks again.
Thank you. So I would say a lot of things have worked well. I know Guyana mentioned how having a specialized court have drastically increased the disposal rates of sexual offenses, and getting matters heard and completed has also increased the number of convictions. But the thing that one thing that came out, I think both from Guyana and Antigua, is the need for specialized personnel. Having judicial officers who are trained and have some experience in understanding gender-based violence and dynamics, and having court personnel who are sensitive to that is something that both Guyana and Antigua indicated was a real strength, because how victims approach the court system and the reception that they receive, and having the court staff that readily knows the referral agencies and which CSO is working alongside of the court and where somebody can get contact for counseling is very, very important. And that's key, that the court administrators and the court staff must be a part of all of the processes and the training, so that because they are the face of the court. They are the persons that people come in contact with. That came out very strongly. And then the other part of it was having the specialized support services. So for instance, in Guyana, the interviews for child victims and vulnerable complainants are not done at police stations, and they are done through a civil society organizations that has an MOU with the government to provide a space that's victim-centered. They have several of these centers in the country where the victims can go to. It's recorded. They can go there and do remote live link that then goes into the court. And they also provide the psychosocial support at that facility with counselors that follow up with the persons and keep them with information about the progress of the court cases. Those kinds of support mechanisms are absolutely crucial, because the court cannot do everything. Just don't have the personnel or the money or the space. And so having those key partners that provide that support is also very crucial. And I think a challenge that is emerging is the need for better data collection, that both of them indicated the need to strengthen data collection going forward, and having the technology to be able to build that into the system of the courts. The courts do have a database that they're using, but there is a need to ensure. So for instance, in the guidelines, we gave a list of indicators that the court can use to track this progress of the court and its success in meeting the needs of victims and defendants. And there needs to be a way for those things to be incorporated into the system, so that from the point of administration, when cases are coming into the administrators and entering into court books, all of that is being tracked and reports are being generated. That is also important, but as was mentioned, is very costly. So any questions before I close? Any question that is pressing, something that came out from the discussion that you did not get clarity on, that you now wish to get clarity on? I see that there are some questions that have been addressed in the chat. Is there anything else outside of those questions that somebody has that they need to get clarity on? No burning issues? Or follow-up comments? All right, well, for me, this has been a pleasure. It was a pleasure the first time around, being the drafter for the first model guidelines and the consultant in that first round. I remember we traveled to several countries face to face and did almost 100 interviews face to face. This time around, it was much more virtual, but it was just as rich. And I am grateful for all the persons who participated, both from the judiciary, the government personnel, attorney general's ministries, defense counsels, prosecutors, the NGO organizations, civil society organizations that participated. We are so grateful for your participation, and that your participation has allowed us to develop this very robust and very rich document, which we are now leaving with all of you as the custodian, that you will now take this document and implement it in your different jurisdictions, and you will continue the advocacy around the issues that it raises and the other needs that are now emerging as a result of us now coming through this process. And we look forward to seeing you again. Maybe I'll see you in another 5 years. Some of you, I may see you before that on another consultancy. And we thank you for your input and participation. Justice Moore.
I just wanted to, first of all, apologize that I won't be able to be with you all tomorrow at the official launching of the revised guidelines, but I'll be with you in spirit. I'll be conducting bail hearings instead of being with you all. But I especially want to thank jurists and CCJ for supporting this process from the very beginning. It's been so critical for us here on the ground. And then most especially Miss Diana, who we're blessed to have in our country in Belize and have had for many years, and perform so many different services. This one in particular is very, very important. I think with the continuing consciousness around gender-based violence in society overall, these rules are going to be really coming into their own now, and new courts will emerge and more justice will be dispensed. Thank you. Thank you all very, very much.
Thank you all. Justice Rajatli, I see you had your hand up.
No, that was my virtual applause.
Okay.
To what Justice Moore was saying, but it wouldn't move. Thank you.
Thank you all. So with that, so next steps, tomorrow we'll have the official launch of the guidelines. After that, the jurist team will be working with the graphic designers, and all the professional layout of it will happen. And then they will give us a finalized document with all the graphics and the bells and whistles and the colors that will be in the document. And Selima will be sharing that electronic version with you, and she will also be doing some hard copies. I don't think this time around they'll do as many hard copies as they did the last time, since we're more aware of climate change and they need to save all the trees this time around. So it will more be e-documents that you will be getting, and she will be sharing that with you in the upcoming weeks when that process is completed. So thank you all. And those of you that are joining us for the launch tomorrow, I will see you then. Salima.
Thank you.
Bye, everyone. Have a great rest of your day. Take care.
Yes, see you tomorrow.
Tomorrow
See
then.
you all. Bye-bye.
Thank you. Bye-bye.